It's punishable by up to 15 years to life. This is the case of the state of Ohio versus Gerald Finley. Can you hear me okay, Mr. Finley?
Yes.
Case number 25 CR 43025. Present before the court is Mr. Finley, right? You're Mr. Finley, right?
Yes. Yes.
Represented by Mr. Wendell. We have Mr. View and Ms. Trainer from the prosecutor's office, Officer Henry from probation. We are here today for a pretrial, but it's my understanding Mr. Finley is going to enter a plea of guilty to one count of murder with the firearm specification, and that we're going to go forward with sentence today. Is that right?
That is correct, Your Honor.
All right. I also understand that there is a stipulation as part of the plea that Mr. Finley has been informed that he has the right to have a hearing on the issue of the notice of requirement to enroll as a violent offender, but he is going to waive that, agree that he's the principal offender, and that applies to him. Is that right?
That is also correct.
All right. Mr. Finley, how old are you?
I think 78.
How far did you go in school?
I had 2 years of junior college.
Are you able to read and write English?
Yes.
Are you under the influence of drugs or alcohol?
No.
Are you taking any medications?
Yes.
What medications are you taking?
Oh, I don't know.
Well, let me ask it this way, Mr. Finley. Are you taking anything that would interfere with your ability to understand what we're doing here today?
I don't think so.
Are you a United States citizen?
Yes.
We've had some discussions about your case. If you enter a plea of guilty to this charge, the notion is to go forward with sentencing today, that you would be sentenced to a period of incarceration of 15 years to life, plus 3 years for the specification. So it would essentially be an 18 to life sentence. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this charge against your will?
No.
I have a document here entitled Change of Plea and Entry, and it looks like on the second page is a signature above the line Defendant. Is that your signature? Tell you what, Ms. Brooke, why don't you go show that to him?
What is it?
This is the plea form that we reviewed together, and he's asking if that is your signature.
Yes.
Did you review the document with Mr. Wendell before you signed it?
I did, didn't I?
That was yesterday.
I'm having a real hard time with my memory.
Okay.
Yeah, but yes, I guess.
All right, you and Mr. Wendell reviewed this form together.
Yes.
Are you satisfied with the representation that you have received from your lawyer in this case?
Yes.
You're going to enter a plea of guilty to one count of murder. This is an unclassified felony. It's punishable by up to 15 years to life. You're also going to plead guilty to a firearm specification. That is a 3-year firearm specification, which will be served consecutively to the 15 years. We also have the issue of your duty to register and to enroll as a violent offender. There's a complicated statutory procedure for that, but the simple part is you have the right to file a motion to contest that, but as part of this plea agreement, you're not going to contest that. You do acknowledge that you're the principal offender and that you're going to register as a violent offender in the event that you ever get out of prison. Do you understand that part of it?
Yes.
All right. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial. You can compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge and the specification, you're going to waive all of those rights. You're going to admit that you did it, and we're going to get on to the matter of the sentence. Is that what you want to do?
Yes.
We also had what we called a motion to suppress in this case. I issued a decision indicating that some of the statements would be admissible against you that you made, and some of them would not be admissible. You also have the right to appeal that finding, but if you enter a plea of guilty to this charge, you are agreeing that you are not going to contest the rulings that I had on your confession. Do you understand that as well?
Yes.
All right. Mr. View, Ms. Trainer, what are the facts?
Your Honor, if the case were to proceed to trial...
Mr. View, I apologize for interrupting. We've had the opportunity to confer with the victim in the case.
Yes, Your Honor.
Victim representative?
Ms. Kennard's been in contact with the victim's representative, notified her of our intent to proceed with the plea today, what the plea was, and the outcome that we expect.
Okay, go ahead with the facts. I'm sorry for the interruption.
Your Honor, if the case were to proceed to trial, the state would produce evidence beyond a reasonable doubt that on September the 7th of 2025 in Deerfield Township, Warren County, state of Ohio, that the defendant did purposefully cause the death of Amelia Vinegar, and that the defendant had on his person and used a firearm in order to facilitate the offense.
Anything on those facts, Mr. Wendell?
No, sir, thank you.
Mr. Finley, did you hear the facts that Mr. View just read into the record?
Yes,
Do you admit that those facts are true?
yes,
Do you understand the rights that you're giving up by entering a plea of guilty?
yes,
Is this what you want to do, Mr. Finley?
yes.
What's your plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you have made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. It's my understanding that the victim is amenable to going forward with sentence today, and that is the preference of all the parties, right?
Yes, Your Honor.
That is correct.
Any reason not to go forward with sentence today?
No, sir.
All right, Mr. View, Ms. Trainer, on behalf of the state,
Your Honor, we would ask that the court enter a sentence of 15 years to life as to the murder count 2, and with an additional consecutive term of 3 years, mandatory as to the specification to count 2. Additionally, the defendant be found to be the principal offender and be ordered to report according to the violent offender database. I know under the statute, in terms of questions of fines and costs, certainly we would stipulate that he is indigent and it would be unable to do that. We have no objection to the court waiving those costs and fines.
Ms. Wendell?
Your Honor, thank you. Certainly the sentence is by statute. We appreciate the state's stipulation relative to indigency. This is what Mr. Finley would like to do, and that's why he's tendered this guilty plea and accepts his responsibility in the matter. Your Honor, thank you.
Mr. Finley, what do you want to tell me, if anything?
Nothing, no.
All right, the court is going to impose a sentence of 15 years to life. I am also going to impose an additional 3 years on the gun specification. This will be served consecutively to the 15 to life term. This is an indefinite sentence, but the 18 years that is on the front end of this is all mandatory time. I do find that you're indigent for the purposes of fines and costs. There will be no financial sanction. I also find that you are to register in the violent offender database. That means that you are the principal offender and that you meet the statutory requirements in that regard. Is there anything else we need to do or anything that I forgot?
Your Honor, only I sent the draft sentencing entry and I neglected to put it's 3 years on under the imposition of the sentence where it says as to the specification to count 2. I left the 3 out there. So if the court wants to just.
I can just fix it right here. I have it on my screen.
Other than that,
It just says a year mandatory. You want that to be a 3-year mandatory prison term to be served consecutively, right?
Correct.
All right.
And I'm assuming the sentencing entry dismisses the balance of the counts of the indictment.
Yes, it's actually the plea entry that dismisses counts 1, 3, 4, 5, and the specifications to those counts.
Thank you, sir.
All right. Mr. Finley, you do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer, to obtain a transcript, or to pay the costs, they will all be provided to you without charge. Good luck to you, Mr. Finley.
Thank you.
Under Ohio Revised Code Section 2903.02 and Ohio Revised Code Section 2941.14, this was a felony criminal proceeding resolved by guilty plea and immediate sentencing in an Ohio court of common pleas. The state of Ohio proceeded on 1 count of murder, an unclassified felony, with a firearm specification carrying mandatory consecutive time. The defendant knowingly waived the right to trial, the right to confront witnesses, and the right to appeal prior suppression rulings, entering a voluntary and intelligent plea in open court. The court conducted a full Criminal Rule 11 plea colloquy, finding the plea constitutionally valid. As part of the plea, the defendant stipulated to principal offender status and waived the statutory hearing related to classification under Ohio's violent offender registration scheme, agreeing that registration would apply if release ever occurs. The court accepted the plea after the state placed the factual basis on the record and the defendant admitted the facts as true. Pursuant to Ohio Revised Code Section 2929.14, the court imposed an indefinite sentence of 15 years to life for the murder count, plus a mandatory consecutive 3-year firearm specification, resulting in 18 years to life, all mandatory at the front end. Financial sanctions were waived upon a finding of indigency. The court advised the defendant of appellate rights, including the right to appointed counsel and a state-funded transcript. Judgment was entered accordingly, and the defendant was remanded to state custody.